Good afternoon, ladies and gentlemen. Welcome to our Board of Commissioners special meeting for Thursday, April 10th at 2025 at 3:30 p.m. This afternoon, I want to recognize Ms. Martha Thompson, who is our outside counsel for this session today, and I'll recognize her at this time.
Thank you.
Martha, press that button on the right and be sure the red light comes on. Thank you.
All right. Good afternoon. I am Martha Thompson. I'm an attorney. I reside in Cleveland County. My specialty has been local government law for most of my career, and I'm happy to be here to assist in this matter. I do want to guide you through what the procedure is today. This is a building inspection appeal. As an administrative appeal, hold on, let me find my... There we go. As an administrative appeal, we followed the statute 160D, which was created and rewriting some other law in 2021 is when this took effect. So it talks about how we set up a corrective action. What happened to my screen? Okay.
Scott, can you get the screen back?
Okay, that's fine. I can start talking it through. Okay, so we're dealing with a corrective action here where the building inspector, in this case it's a building inspector, made a decision which they are required to do by law, and shall, if when they do their inspection, the result is the building is in a condition that constitutes a safety hazard, a fire hazard. I understand the fire marshal was probably involved in this as well, that renders it dangerous to life or health or other property, then they shall make a finding in writing, notify the property owner, require whatever action needs to be taken, which might be repairs, it might be remediation or demolition, something that has to happen. There isn't a right of appeal for due process in that, but the remediation must take place, and it might be vacate because the building's been condemned, and there's a 60-day requirement by statute to for the property owners to take the action that's been assigned to them. There is a right of appeal. If that appeal is taken, it stays the action, so nothing can happen at that point. In this situation, the appeal was made, and the appeal goes to, in this case, this body. It goes to a board that the county has designated to hear those type of appeals. Sometimes you have ones that goes to the board's adjustment. In this situation, Burke County has not delegated that, so it comes before this elected board. So you have a reasonable time in which to hear the appeal and then render a decision, which must be done in writing. So this is a quasi-judicial, by law, this is a quasi-judicial hearing. So you're acting as a group of judges. So you think of the 3-panel judges that did redistricting, for example. Well, this is a 5-panel, four-panel group of judges here that you would render your decision, and it would have to be by simple majority vote as to what your decision is after you hear the evidence. So in this situation, as quasi-judicial, you are hearing the evidence that's provided to you. You're not looking at things outside of what's presented. So this is not a policy matter. This has to deal with one particular situation, one owner. In this case, it's an entity. So that's why it's quasi-judicial. It doesn't have anything to do with what the voters believe or think or what you think might be best. It has to do with, has the law been followed? And in this case, the administrator the staff person, in this case I think it was the building inspector and perhaps the fire marshal as well, made a decision and interpreted the building code and the fire code in one way. So your role is to determine, was that interpreted correctly? It's not what's best for our constituents, it's was the law interpreted correctly? Was the statute interpreted correctly? And just for reference purposes, who can sit in the legislative role and who can sit in the quasi-judicial role is on this chart. You as Board of Commissioners can sit in either role. Usually you're legislative. Here it's quasi-judicial. So building inspection appeals falls under the quasi-judicial in the second quadrant as the type of matter that you can hear. And what can you do? What action can you take? You can affirm, reverse, or modify a building inspector decision is what we're dealing with today. And only thing you can listen to is competent evidence that's in the record. Here, what our record consists of is what has been previously provided to you. That would be the record that staff prepares, that's based on all of the findings and what they dealt with at their hearing stage, and any additional evidence that was presented by the petitioner, the building owner. To the extent new evidence is needed is going to depend upon the facts. So you may hear from both sides that they agree on the basic facts, but they have some things they want to supplement. I expect you will hear a review of the facts as they already exist, but if there's anything new that needs to be provided, they will do that. They're probably going to do some testimony. Either side can present sworn testimony to you. They can present expert testimony to you. They may disagree on the legal question of how to interpret the ordinance. That's something that you may hear and can decide. If you hear things that are outside of competent evidence, I am here to guide you in that, and you can certainly ask me, can we hear that? If I hear something that I know is incompetent evidence, I'll mention to you that this is something that you would not consider. So you would just, we can stop the testimony at that point or redirect, or you would just disregard something that would be incompetent for a reason. And this is our screen. So what would be competent? A witness with firsthand knowledge. It's not hearsay, oh, I heard such and such, or I think such and such. The expert testimony also. So matters of opinion, I don't think it's that bad, I feel this way, that would be incompetent evidence. It's material if it relates to the issue. It's immaterial if it's something outside of the four corners of what we're dealing with today, such as community feedback. And everything, again, needs to be on the record. So the documentary evidence, to the extent it's already been presented, will probably be referenced that it's made part of this record by either side, because I think both sides have presented something about this. And your decision will be, you will, one of three things. You'll either affirm the opinion of the building inspector and what his finding was, what his direction was, or you can reverse it, in other words, deny it, or if you hear something that you think was inaccurate in the evidence today that would modify what's happened. The last thing that would need to happen is a written decision after you vote. And that written decision just has to be prepared within a reasonable time, and it would contain a finding of facts and the decision, and I will be able to guide you through that and help you prepare that, not today. It doesn't have to be, that doesn't have to be done today, but and you would hear this. Obviously, Mr. Board Chair, you are presiding over this and making the rulings as to evidence and calling the witnesses, allowing them to call witnesses, but calling each side, allowing for testimony, cross-examination, recross, redirect, and even rebuttal evidence if appropriate. Any questions?
Thank you, Ms. Thompson. Any questions of Ms. Thompson?
Okay.
All right, thank you very much.
Thank you.
All right, with that, welcome everyone again. I'll note that all of our commissioners are present today with the exception of Mr. Burns, who is out due to illness. And we've already introduced Ms. Thompson. Mr. Dylan Laws, our attorney representing professional staff. Also acknowledge Pastor Tommy. And Tommy, I'm going to ask you to pronounce your name for me one time, if you would, please. You will turn that button right, the right button. If you'll press it, a red light should come on the bottom there toward the base of the. There you go. You got it. Okay, just leave it just like that. Now tell me your name.
Tommy Lewis.
Okay, I may go with Tommy. Will that be okay?
It's okay.
Thank you. I don't want to mess up your name. Okay. All right, I will remind all speakers, including commissioners, that when you come to the podium, please be sure the red light is on, and Mr. Laws, be sure yours is on if you speak from the table there, okay? All right. Gentlemen, I'll entertain a motion to approve the agenda as presented today.
So moved, Mr. Chair.
Thank you, Mr. Vice Chair. All those in favor signify by the uplifted hand. 4-0, Madam Clerk. All right. This does bring us to the decision item for today, Community Development Appeal Order to vacate 8123 George Hildebran School Road, Marshallese New Beginnings Church. And with that, I'll recognize Mr. Dylan Laws, our county attorney representing our professional staff today. Mr. Laws.
Thank you, sir. I'm going to give my opening up here, if that's okay. And you'll have heard a little bit of this already, but I think it's important. Today, you are being asked to proceed in a manner that you may not be particularly familiar with. This is a quasi-judicial evidentiary hearing. That means it's like a court hearing like you see on TV, and you all are our judges. While you may see yourself in a political role, and that is true in most cases, today you are not. You are acting as judges, and this is not a political forum. The political decision has already been made, and that is what has been appealed to you today. Quasi-judicial hearing is not a popularity contest. It is a decision constrained by the standards in the law and based on the facts presented. Your discretion is limited. Your decision can rest only upon the competent, relevant, and substantial evidence that is entered into the record today. And what exactly will that evidence tend to show? You'll hear that this building is one purely designed for education and not for residential occupancy. You'll hear from experts that'll speak to the terrible conditions currently in place at the Marshallese New Beginnings Church, from exposed live wiring and overloaded electrical systems to leaking sewer gases. You'll also hear about the extended time frame that these issues have been occurring and the numerous chances that have been granted for the church to remedy said issues. Lastly, it is clear from the appeal filed by the church that no allegations were made about the law or even that the prior order was incorrect. I ask that you listen carefully to the evidence presented today that was compiled by these experts and use only that to make your decision. That is what is intended by the General Assembly, what is required under the law for a quasi-judicial hearing. The burden of proof is on them to prove that that decision was incorrect. Thank you.
All right, thank you, Mr. Laws. This time I'll ask you to call your first witness.
Yes, at this time, I would call Mr. Holden to the stand.
Mr. Holden, will you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you.
Yes, Mr. Holden, I'm not used to sitting beside my people I'm questioning, so I hope you can
all right.
keep track of me.
Okay.
Mr. Holden, how long have you been with the building inspection department?
Building inspection July 1st this year, I'll be 25 years.
Okay. And before then, what were you doing?
I was with Catawba County Building Inspection,
Okay. About how long did you do that?
2 years.
Okay. And what were you doing before that?
I was a police officer for the city of Morganton.
Okay. And have you any other relevant experience in this area?
I'm a licensed plumber with the state of North Carolina.
Okay. And did you prepare the prior report in order?
I did.
Okay. At this time, I would move to qualify Mr. Holden as an expert witness.
Okay, thank you. You are qualified, Mr. Holden. But is there a special way I need to do that? Thank you. You have any objections to that, Tommy?
No.
All right.
I would actually object to him objecting to anything. The board, or the entity he represents is a corporation, and under the law of North Carolina, a corporation cannot be represented pro se by an individual. They must be represented by an attorney. That qualifies in quasi-judicial hearings as well, and I have some law on that, if I may present it.
Any counsel on that?
North Carolina Supreme Court has ruled that administrative actions do not qualify under 84-4 for the unauthorized practice of law, so he is permitted to.
I would disagree with that,
compensate.
and if I can present some evidence why I disagree with that.
Okay.
So.
Mr. Chairman, may I ask a question?
Yes, sir.
Dylan, what is the, are you saying that he represents a corporation and a corporation cannot be? Is that what you're saying?
Yes, that is correct. Under this case I've just presented to you, a corporation cannot practice law. It is a personal right of the individual. It cannot appear and represent itself either in proper person or by its officers. It can only do so by an attorney admitted to practice law. And a corporation must be represented by a duly admitted and licensed attorney. And then I provided in there as well the state's ethics opinion that specifically applies to quasi-judicial hearings on zoning and land use. And it says the role of the governmental body is to receive evidence and make decisions, and it is clear that on the appearance of behalf of another person, firm, or corporation in representative capacity, which is, they are a registered corporation on the Secretary of State's website, that it cannot present evidence, cross-examine others, and argue on the law at a quasi-judicial hearing in these proceedings. And as I understand it, the law is fairly clear on that, and the ethics would follow that as well, and that it is a Class 1 misdemeanor to do so.
Ms. Thompson, you have another opinion?
Yeah, Mr. Chairman, there, in 2014, the Supreme Court of North Carolina ruled that although this is a case from 2002 from the Court of Appeals, it's not the definitive answer on this, but the Court of Appeals has been overturned in that respect on a case that went up in 2014, the Twin County Motorsports case that said that it's not an unauthorized practice of law for a corporate officer to appear before the DMV because that's an administrative proceeding and not an action or proceeding as the statute contemplates in 84-4, the North Carolina General Statutes specifically talks about a judicial body, including the Industrial Commission or the Utilities Commission, but it doesn't say anything about administrative actions, but the Supreme Court has says administrative actions fall outside that. So Nothing specifically talks about a quasi-judicial proceeding, which falls under the administrative actions, in my opinion. And I think at best, the law is gray. I think there's an argument, that there's certainly a strong argument that he would be permitted to proceed, but that would be a decision by this body as to whether to allow him to proceed on his own behalf or not, because the law is not clear, as Mr. Laws is arguing.
All right, thank you, counsel. I appreciate the opinion of both. I'm going to allow Tommy to represent himself here.
And I would like to just, on the record, say that objection is for every action he takes that could be considered the practice of law. So that way I don't have to interrupt every single time, if that's okay.
Okay,
You can just note that objection, continuing objection.
duly noted. Thank you very much. All right, continue on.
Did he, just to clarify, was he objecting in any way to qualification of an expert witness?
Tommy, did you object to any of the qualifications of the witness?
His qualification?
Yes.
No?
Okay, thank you.
Mr. Holden, do you have a copy of what's been marked as exhibit number 1?
I do.
Okay. And what is that?
It's a condition of structure report that myself and staff have made on the structure.
Okay, and is that what you used to make your prior decision?
Yes,
And are those records kept in the regular course of your business in these actions?
yes,
And is it a fair and accurate representation of those?
yes.
I would move to admit that as exhibit number 1, and I believe you all actually have a copy of that one. And I believe one's already been presented to the church.
All right, thank you, Mr. Laws. For the record, I'll announce that exhibit number 1 has been accepted into evidence. Are there any objections to this exhibit? Seeing none, we'll continue.
Mr. Holden, could you briefly just describe the property for me that's located at 8123 George Hildebran School Road?
It's a previous educational occupancy and assembly, which it was used as a school. And it's, we had a complaint that it was being used as residential. And our staff went and made a visit, and we found out that it was not only being used for a church, but also for residential R2.
Okay, so it is not being used the way it is designed to be
That's
used?
correct.
Okay. And can you just switch occupancy types like that?
You cannot.
What sort of process is required to switch occupancy types?
The process would require an,
Excuse me, Steve. Mr. Laws, would you move that microphone over more in front of you if you don't mind? Sure. You might have to move, there you go. That mic.
Is that any better?
I want to read the law of the code first. So on section 302, it advises us that structures or portions of structures shall be classified with respect to occupancy in one or more of the groups listed in this section. A room or space that is intended to be occupied at different times for different purposes shall be comply with all the requirements that are applicable to each of the purpose for which the room or space will be occupied. Structures with multiple occupancies. Where a structure is proposed for a purpose that is not specifically provided for in this code, such structure shall be classified in the group that the occupancy most nearly resembles, according to the fire safety and relative hazard involved.
Okay. And so has the church ever completed any process to switch designations?
No.
Okay. And have they been given the opportunity to do so?
Yes.
Okay. And then let's just move sort of the current condition of the property. Did you go out and inspect that property?
I did.
And do you remember when that was?
Let's look at my timeline.
Oh.
inspection on September the 16th, 2022.
Okay, so that was one of your earliest ones?
Yes.
And did you inspect it again in
Yes.
preparation of the most recent ruling?
Yes.
Do you remember about when that one was?
Done it January 2024, we done a room-by-room inspection and noted any code violations.
Okay. And out of those violations, just what was the most important issue you found?
The first one was, it was an educational occupancy and it was being used as a residential occupancy.
Okay. And what about the electrical system?
And the electrical system was one of the main reasons because of life and safety and dangerous to the children that were occupying it and the people that were there.
Okay. Can you speak a little bit on those electrical issues for us?
So we found there to be open wiring we found open electrical panels, which was one of our first violations that we found that was what we thought was the most severe life safety problem. And under NEC Article 230, all panels must be covered so that nobody can just actually walk up and put their hands into it and get electrocuted.
Okay. And are there any pictures of that in here?
There he is,
Could you please,
photo 1 on
Okay.
page 5.
okay. And so those do violate code?
They do.
And you stated that, could you please reiterate the danger of that?
So with a panel open, all your bus bars and electrical is open for anyone subject to just walk up to it and touch it and be electrocuted.
So in your opinion, could someone die?
Yes,
So this is a matter of life safety?
very unsafe.
Okay. And then, what other electrical issues did you see?
So on photo 2, we found that there was a panel in the bathroom. And with a panel in the bathroom, that is under NEC 240.24B. Electrical panels shall be readily accessible and shall not be located in bathrooms or in the vicinity of easily ignitable materials such as enclosed closets. We found this in the bathroom where you could just reach up and touch it in the bathroom. It also had Romex coming out of it, which was wasn't installed per code for the connectors, and also Romex being exposed.
Can you explain what that is for?
So Romex in residential is behind sheetrock normally, you can cover it, but Romex cannot be exposed except, it cannot be exposed because of the nature of it being tore or somebody skinning it and touching it and get electrocuted. It has to be in conduit or behind sheetrock.
Okay. Were there more electrical issues?
There was.
Can you go into some of those for us?
So photo 3 is showing a panel with the same thing with exposed wiring. And then photo 4, we have exposed Romex and then not supported every 4 feet. Photo 5 is exposed Romex. Photo 6 is exposed Romex, and then we have just receptacle box and not in, it isn't in the box correctly because you need the correct connectors. Also, it's not in conduit.
Okay.
So photo 7 would be the same thing, exposed Romex. And photo 8 would be the same thing. It'd be exposed Romex and not properly secured and supported.
Okay. So those same dangers you mentioned earlier, those present in these pictures as well?
Yes.
So it's not just one violation, it's
That's right.
multiple?
It's multiple.
Okay. And then what about,
Mr. Chairman, can I interrupt just for a second? The first inspection you did was in 22, is that correct?
Yes, sir.
That's when this was first acknowledged?
Yes, sir.
And then it's 24 was the last time we actually done a walkthrough, and this is where we're at now on
Yes, sir.
this. What was the difference in 22, the first?
Nothing.
Nothing, okay.
so after that, are there any issues with the heating of the facility?
So in the heating, we found that there wasn't properly, circuits were overloaded from the heating sources. The code would require you to have a heating source that would maintain 68 degrees, 3 foot above the floor. And we found no heat source except for portable heaters. Some of them were kerosene heaters. And then again, with the electrical drop cords and the amount of heaters, it was overloading the circuits.
So you mentioned overloaded circuits. Can you speak a little bit more about the potential issues with that?
So in the code, electrical panels, let's see here, it said drop cord powered heaters and it's over 80% heating electrical capacity. When we do the calculations, one heater is usually meets this. And when you do a multiple 2 or 3 heaters, then you're over the 80% on one circuit. And we had multiple heaters on one circuit.
Okay. And
And that would be NEC Article 240.24.
Okay. And what sort of danger does that pose?
A fire hazard because of overloading the cores, they would overheat and then cause a fire.
Mr. Holden, while the chairman's done that, did you notify the property owner in September 2022 of the violations? So,
We did, he was with us
Okay.
in the walkthroughs, all walkthroughs, he was very
so they've been aware
pleasant
of
and
this
let us walk with us.
well over 2 years ago?
Yes, sir.
Okay, thank you.
Then you also mentioned kerosene heaters.
Yes.
Were those being used as they're intended?
The only issue we seen was how close they were to the beds.
Okay. And so does that pose?
Yeah,
any
just
hazard?
catching the material on fire.
Okay, so that poses a fire hazard. And then what about structural issues? Do you have any issues with those?
We found structural defects and roof leaks.
What sort of, do you have pictures of those in here as well?
On the structural, on chapter 14 or chapter 15, the roof deck has to be covered with approved covering, and the lumber must be kept at 15% or less moisture content to avoid rot. So with no windows and no roof covering, we're getting water into the structure, which is causing wood rot.
Okay. And do you have pictures of that in here?
We do.
Which pictures? are
Okay,
those?
photo 15, 16, 17, and 18 on page 8.
And then, were there issues with the plumbing?
There was.
What sort of issues did you see there?
Okay, so in the plumbing, I'm going to read 102.3, which is the maintenance. Plumbing systems, materials, and appurtenances, both existing and new and parts thereof, shall be maintained in proper operating condition in accordance with the original design in a safe and sanitary condition. All devices or safeguards required by this code shall be maintained in compliance with the addition of the code under which they were installed. The owner or the owner's authorized agent shall be responsible for maintenance of plumbing systems. To determine compliance with this provision, the code official shall have the authority to require any plumbing systems to be re-inspected.
And are there pictures of those issues in the report?
They are.
Which pictures were those?
Okay, photo 19 through 30 on page 9.
And can you speak to any of the particular issues in those pictures?
So on photo 19, you'll see that one of the lavatories is missing, and you'll notice that the uncapped pipes are emitting sewer gases into the structure.
And what about the rest of the pictures? What are those showing?
So photo 20 is just, it doesn't meet code because the P-trap is not installed correctly. Photo 21, we're missing some water outlets, some toilets with just open pipes in the floor. Photo 22, I'm not sure on that one on the plumbing. I believe that was just a leak. But on photo 23, we have a makeshift shower. We have just a toilet, and most of these don't have water. They're using water out of a bucket. Photo 24 is just showing the condition of it, and 25 showing the buckets of water, which it doesn't have. Photo 26 is just a shower with the mold. Photo 27, the buckets with the water. Photo 28, none of these lavatories work properly. And on photo 29, we're missing a lavatory with an open pipe. Then photo 30, we have a shower, and some of the, we're also required to have hot water. And it's saying that hot water requirement is for culinary, plumbing systems, laundry, bathing, and washing, etc. And that's North Carolina Building Code 607.1, and we do not have hot water to every fixture.
Okay. So, is this, I believe the board is already slightly prepared for this, but is this the first time you've ever interacted with the church?
No,
And have you ever had a hearing on the property before?
yes.
what's been marked as exhibit number 2. Mr. Holden, what is this exhibit?
This is the notice of condemnation of the property, and it was to set the hearing for a certain date.
And is that your signature on there?
It is?
Is this a fair and accurate copy of that letter?
Yes, sir.
Have you altered it in any way?
No, sir.
I would move to accept that as exhibit number 2.
Exhibit number 2 is accepted.
Let's see. So this letter, does it state anything about a prior hearing?
Yes,
Okay. And did you, as far as you recall, did you have that hearing?
we did.
Okay. And what was the date of that hearing?
That hearing was November the 9th, 2022 at 8:00 a.m.
It's been marked as exhibit number 3. Mr. Holden, what is that?
It is a order of remedy of the property for 8123 George Hildebran School Road.
And did you prepare that as well?
I did.
And is it a fair and accurate copy of that letter?
Yes.
Have you altered it in any way?
No, sir.
I'd move to accept that as exhibit number 3 at this time.
Exhibit number 3 is accepted.
Mr. Holden, what was this letter for?
This letter was the order given by myself due to an unsafe educational occupancy structure located on the noted property. It was also, issuance of this order was allowing 60 days for remedy of the structure.
And what was the date of this letter?
The date of the letter was November 9th, 2022.
So this one was prepared after that first hearing.
Yes.
And was any, let's see, was that any remedy conducted within 60 days of this letter at that time?
No.
This time I'm showing you what's been marked as exhibit number 4. Do you recognize that?
I do.
And what is that?
That is a permit for the Marshallese New Beginning Church
Do
to
you,
renovate the school.
okay. Is that a fair and accurate copy of that report?
Yes.
Has it been altered in any way?
No.
At this time, I'd move to accept that as exhibit number 4.
Exhibit number 4 is accepted.
Mr. Holden, are you able to tell me the date that that permit was issued?
The date was December the 19th, 2022.
And when did that permit expire?
It would have been December the 19th, 2023.
This time showing you what's been marked as exhibit number 5. Mr. Holden, what is this document?
This would have been to schedule an inspection and make an inspection on the church.
Okay. And is this a fair and accurate copy of that sheet?
It is.
And has it been altered in any way?
No.
At this time, I move to accept that as exhibit number 5.
Okay, this exhibit number 5 is accepted.
So, Mr. Holden, what exactly does this document show?
This would have been an inspection scheduled on a certain date to look at a certain item in the church, which this one would have been an above ceiling electric.
Okay. So, what does this document show about the permit status at this time?
That it was
Look at the top right.
expired on December the 19th, 2023.
Okay. And from this document, does it show that any progress was ever made on the permit?
No, no inspections and no progress.
Okay. So, just to clarify, no inspections were ever made before this permit expired?
That's
Or
right.
no progress was ever made before this permit expired?
That's correct.
Okay. So, in that case, are the issues you previously mentioned, from your recent inspection, are those new?
No.
Has the church been previously given an opportunity to rectify those issues?
Yes.
And have they done so?
No.
So, when these issues were found, and you did your most recent inspection, did you post the building as unsafe?
I did.
Okay. Did you find the building to appear especially dangerous to life because of bad condition of the walls, overloaded floors, defective construction, decay, unsafe wiring, and inadequate means of egress?
Yes.
And then did you affix a notice of dangerous character to a conspicuous place on an exterior wall of the building?
Yes.
And did the church fail to take prompt corrective action as required?
Yes.
For that prior hearing, did you all mail and hand deliver a notice of hearing to the property owner?
Yes.
And did you have that hearing?
We did.
And do you remember your findings from that hearing?
For the building was unsafe for life and habitation.
Is the building in such condition that it constitutes a fire and safety hazard?
Yes.
Is it dangerous to life, health, and other property?
Yes.
And what did you order to be done?
The order to be done is to vacate the property.
Does that mean that they can't continue to operate as a church?
No.
And have you given the church guidelines to try to rectify these issues?
Yes.
Okay. And at this time, is there anything else you think it's important for this body to hear?
No, sir.
Okay. That would be my questions for him.
All right, thank you, Mr. Holden. This time, Ms. Laws will call your next witness.
So, at this time, you would ask Tommy if he has any questions of this witness.
Okay, thank you. Yes. Mr. Holden, if you will come back. Tommy, do you have any questions for Mr. Holden?
Not at this time.
Okay, thank you. All right, Mr. Laws, now you may call your second witness.
At this time, I would call Mr. Robert Bishop.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you.
Yes, sir, could you please state your name for the record?
Robert B. Bishop,
And what is your current occupation?
the Chief Fire Marshal for Burke County.
Okay. And how long have you been doing that?
This July will make 6 years.
Okay. And what were you doing before then?
I'm a fire engineer for the town of Longview Fire Department.
And so how long have you been in the fire service industry?
23 years, almost 24 years.
Okay. And did you help prepare part of the prior report for this order?
Yes.
At this time, I'd move to admit Mr. Bishop as an expert witness in this case.
No objections, Mr. Bishop. You will be considered expert witness.
Yeah. Mr. Bishop, so you,
Any objection, Mr.?
No.
Mr. Bishop, so you stated that you did prepare part of the report for this.
Yes.
Could you, does that begin on page 18, as far as you're aware?
That is correct.
So, for most of us, this is, not a routine document. Would you be able to just sort of speak on some of your findings from this property?
So pretty much we're gonna go down a checklist, when we do an inspection, it's pass or fail. So anytime we fail, whatever component of that inspection it is, we'll get a reference back to the code. And then we have an option to put a comment in there to either highlight the repair that will need to be made or, just what we can do to mitigate the present issue.
Okay.
So you want me to just go down the line, or you want?
Yeah, as of right now, if you can just sort of speak to some of the findings you have in this report.
All right, so just starting at the top of the inspection report, it starts with our exits. Doors serving rooms or spaces with an occupant load of 50 or more should not be provided with a latch or lock unless it's panic hardware or fire exit hardware. So we had some spots in the church where we had furniture, things like that in the way. During the initial inspection, if it was something they could take care of while we were there, they did move it. That kind of falls into your next fail, which was means of egress and obstructions. On the comment, you see main hallway near the sanctuary has the emergency exit door location that's been altered to be inoperable. That's a corridor from the front to the rear of the building. It was an exit door that went to the courtyard that had been bolted up. So, it's fire code and building code. Going down, door opening force. So anytime we open a door to a designated emergency exit, it shouldn't take more than 5-pound pushing force. It has several doors you kind of had to shoulder into to get to open.
What sort of danger does that pose in a real live fire situation?
The inability to safely exit the building during a fire.
And are there certain parts of the population that are more susceptible to those issues?
Younger folks, elderly.
Okay. You can continue down the list if you like, just a little bit.
And just kind of continuing on, multiple emergency exit doors in the building are difficult to operate or do not operate as designed. And, not operating as designed could be anywhere from being, changed over to being an inward swinging door versus an outward swinging door, or, residential hardware, locking hardware being put on it, just various types of situations.
And then I see in here that there's also quite a long list in the category of electrical checklist, and I previously heard Mr. Holden speak on the electricals. Would you mind speaking on that a little bit?
Yeah, the fire code is a maintenance code. It's, we're going to go in every 1, 2, 3 years, depending on type of occupancy. The electrical component of it's significant just because of the danger just with electricity, block breaker panels, overloaded outlets, drop cords being used as permanent wiring. We block those areas. It's hard for, if you have fire, for firefighters to get in there and kind of identify what's what on the breaker panel. Just build up with heat. Naturally, you're going to have heat build up in a breaker panel. So.
Okay. So would you say that is there a high amount of potential for fires in this building?
Yes, sir.
And from what you said earlier, there's also difficulty getting out in case of a fire.
Yep, some areas, yes.
Okay. So would you consider this building to be safe?
No.
Would you consider it to be dangerous to life and safety?
Yes.
And would you consider it safe at all for anyone to be residing in currently?
No.
And do you agree with Mr. Holden's findings that this building should be vacated for anything other than religious gatherings until these issues are fixed?
Yes.
Nothing further.
Tommy, do you have any questions for this witness?
Oh, no.
Any questions from the commissioners?
Excuse me, y'all, you understand that you really don't speak English all that well, and he cannot read these pieces of paper or any of the notices that have been delivered to him. There has not been an interpreter taken to the church when those inspections were being done. These people,
Sir,
these
sir,
people have no idea what's going on.
you'll be seated, please, sir. Thank you.
Okay, well, it needs to be notated that he's being charged and he has no idea what's going on.
In fact, you're doing this, you are violating his rights by not allowing him to understand.
He can't even defend himself right now.
You're talking about people he's found in other homes.
You're getting ready to make him homeless. And I
Please
see,
be
I see
seated,
Mr.
sir.
Phil Smith, he thinks this is funny, but he's the one that's,
You
you
haven't
know,
heard about the words you said.
I'm going to ask you to be seated, please.
I'll see myself out.
Thank you. We do have an interpreter present if it's needed. Any comment, do you need an interpreter?
Yes.
Okay.
Then you need to start this whole meeting over because he hasn't heard a damn thing you said. And yeah, Phil, don't look beside her. So was that the sand N-word or the slant eyes that you called him yesterday? Guess how many people heard that?
Bethany, are you prepared to interpret?
Yes, your honor.
Come on.
Sir, may I say something? Just, we'll take 2 seconds.
That's not appropriate.
No, sir, I'm sorry.
You cannot hold a trial with someone. I advocate myself.
I'll ask you to leave if you continue to interrupt.
You cannot hold a trial for someone that can't speak the language. This is absolute bullshit. You should have listened to that
Officer.
lawyer the first time. I'm leaving. Hands are up. I love you guys.
Thank you. Thank you.
Yes, sir. So I was wondering if there is a possibility that we can move this to a later date so I can have time to go over everything and really understand it.
Can I say something? Is this appropriate for me to say something now?
Is it a question for the
I mean,
witness?
we've had, since 22? Pastor, we love you guys. Thank you for being here. I know this is a little disconcerting, and we love you Marshallese people. But you've been here 2 years, and how have you started the church here without not being able to communicate? I'm not sure I understand how this is working, where you were there for the inspections and this has been 2 years in the past. Has there been nobody to help you through this process saying, hey, this stuff's all messed up, we need to get it fixed?
This is not the.
Okay, I'm sorry.
We'll strike all that from the record, please.
Yes, so we did follow the findings that they had presented to us, and I have all of these reports here. I have all this stuff here in front of me.
Mr. Bishop, was there ever an interpreter present when you were on the scene?
Yes,
There was an interpreter present when inspections were made?
yes, stand by and I'll give you a date.
Mr. Chair, I think the appropriate question for the petitioner at this point is, the fact that he is now asking for more time. Has he at any point until a moment ago, asked for a continuance or additional time?
You look on page 21, the 1/31/24 inspection date on my comment section. I listed all the inspection participants, and the last one was the SS interpreter. And during that inspection, the interpreter stayed with us, went around the whole time, kind of explained to
Excuse
them
me,
what we were
sir,
finding.
can you give me a second to grab page number 21? Is it under the unstapled copy of the report here, sir?
Tommy, at any time during this process, have you asked for a continuation of this case?
No, like honestly, I didn't understand all the proceedings and I wasn't quite clear on what I was supposed to do on my end, sir.
Can you ask him if he has ever requested a continuation of this case?
Lain mendengar puji kan angin dengar jangan lagi dengar kaji tu boy. Yang biarkan ani benar PSI yang mereka cuma sebelum sebab. I'm console to vision. No, that wasn't.
Yes, thank you, sir. So, like I said before, I wasn't really aware of the process and that I would be able to do that. I had spoken to the Marshallese embassy as well as the consulate in Washington to seek some additional support, but I was not aware that continuation was allowed for me.
Mr. Chairman, we would object to any continuation. This has been an ongoing issue for years at this time. He's had the opportunity to speak with a lawyer way before now, and I've just been given 2 invoices for Marshallese interpretation for 2 different site visits on 131 and 423, both in the year 2024. The opportunity to continue this or seek counsel was long ago. I don't believe it proper to halfway through decide that things aren't going well for you and that you should have prepared and just ask it to be continued. We've been prepared, we're here, and this has been scheduled. And it's, as mentioned, it's been a year-long process of issues.
Okay, thank you.
Yes, sir. So actually, yeah, regarding that, I just wanted to direct your attention to some of the pictures and the findings that they had here on the doorknob here.
What page are you looking at?
You know, I don't, I'm so sorry, sir. I don't have a page number on here. These are my own findings, and I didn't realize that I was supposed to bring them and give copies to everyone present, but I have it here in front of me.
Doesn't have to have copies for everyone, he can just show you themselves.
If you bring them up so we can see them, please.
May I see those as well first?
Yes, if you'll show them to council, please.
This is what one by one.
Yes, so basically, you can see here. So we messed up, we fixed all of this here. It didn't work before, but we fixed it, and now it's working.
Objection. This needs to be on the record, and I can't hear any part of it.
If, yeah.
Okay.
You'll need to explain the picture and tell us what we're seeing.
I think, Mr. Chairman, I think what he's doing at this point, the question is this about a request for continuance, or is this about evidence he would like to present?
The question at this point, is he requesting to present evidence, or is he wishing to request a continuance?
Yes, sir. I'd like to ask for some grace time if we could do a continuation so that I can get all of this set up correctly. Yes.
Araban kejawal kejubaran sacrifice kejubaran itu in kejarat tarinayo.
Yes, sir. So, regarding the codes here, as you know, I'm not from America.
Objection, that's no relevance to a continuation at this point.
We're not presenting evidence.
So if he wishes to present evidence that he's got with him, Mr. Chair, he can do that in a few minutes. He doesn't need to have copies for everybody, he can present what he has.
Yes. May I ask if we could have a grace period to have a continuation so I can have some time to get this all set up correctly, sir?
I would
Is it
object to that.
appropriate to have a recess where we can discuss this matter? Okay. Thank you, Mick. Go ahead and have a seat. We're going to call for just a moment of recess, and the commissioners, let's go back in here in chambers where we can have a discussion. Is that acceptable?
We
I believe
can
it,
take- we
yeah.
can take a less than majority back there.
Less than majority. So given
We
that
can
we
do it in
have-
shifts.
Okay. Given that we have an even number of commissioners, can we take 2 commissioners and yourself? Okay. Okay, we're going to recess for just a moment where we can have some discussion, and then we'll reconvene.
May I clarify if the witness is still on the stand at this time, or can he step down?
Yeah. Tommy, do you have any questions for this witness?
Yeah, I'm good. I don't need anything right now. I have no questions or further comments.
Okay, thank you. You're dismissed. Thank you.
for this motion? That's how you get started.
Okay, we'll consider ourselves back in order. Tommy, I think now you have someone there who can interpret for you. So you have, we consider that you requested a continuance. On what basis do you ask for that continuance?
Oh, thank you. Yes, so my understanding was that I did not need any legal representation, but I'm hearing conflicting things now, and that was what I initially had thought.
Menu yar kan cawa ikan photo menu request ngan kan extension ngan makai ical kabar malang.
Yeah, and so I brought my own report here. I was just going to ask for an extension and continuation so I could have someone who would be able to properly represent me.
All right, thank you very much. All right, gentlemen, we've heard a request for a continuance.
And I would like to object to that and possibly also be heard on it if possible.
I'm sorry, repeat.
I would like to object to that and possibly be heard on it as well.
Okay, please state your,
Yes, sir. So the pastor has mentioned not knowing that he needed to have legal representation and the lack of an interpreter. But the issue is that because of the amount of time this has been going on, he's well aware of the issue, has submitted appeal forms in English that he has handwritten and that have been typed and signed by him. There are invoices showing that interpreters were at site visits. Just because we got partway through a hearing and maybe he decided it wasn't going well for him, now tries to get an attorney is not sufficient grounds. And to say he didn't understand these proceedings or that he needed representation is something he should have gotten before. And just lastly, to say that he didn't understand these proceedings or has an issue with English, he was able to go on the news just days ago in giving a public interview speaking himself about these matters. So either he can sufficiently understand these proceedings or has the means to have sufficiently figured out what he needed to do these proceedings far before essentially we're finished up with our case.
thank you, counsel.
Ask him if he has a response.
Do you have a response to that?
Rapa ngan company mana ijulor oleh bentak ko farm mana putting narapa. Aku rumicir.
Yeah, so I just wanted to say, it is correct, when I had spoken earlier, as well as had an interview, I can speak English, and I had spoken English with them, and I knew that the fire inspector had come as well as the building, and I did understand all of that, but as far as the legal proceedings, it's pretty heady, and it's a different form of English with the legalese, and so that was why I was requesting that.
Okay. All right. Hearing that, I'll ask the board, commissioners, is there a desire to continue this case?
It's no for me, just so everybody knows.
Okay, I'm going to take that as a motion. All those in favor to not continue this case and move forward, please signify by the uplifted hand. Are those wishing to continue? Be 3-1. Okay, so we'll continue with this case. First question to Tommy. Is there anything about the evidence that has been presented so far that you do not understand?
He was just asked questions of the witnesses.
Yeah, page number 5,
Apa cara
photo 1.
asking us this question.
Yes, so my understanding was, so in photo one, you'll see obviously the pictures from that inspection. And my understanding was there were people living there prior to us moving in, and they'd been there.
Objection. I feel like
some
he's
time.
testifying at this point, and not only is, we're not to this point of questioning at this point, he hasn't been sworn or anything.
The question is, do you have a question for one of the previous witnesses?
Tell him he will have.
So sorry, could you repeat for the interpreter? I apologize.
I'm sorry.
May you repeat the question for the interpreter? I was finishing the interpretation, didn't hear the first part of your question, sir.
Yes, the question right now is, does Tommy have any questions for the first two witnesses?
And that he will have a chance to give his side of the story and present evidence.
I'm good for right now, no.
And please be sure he understands he will have a chance to present his testimony afterwards. Okay. All right, we've heard from two witnesses. You have finished with your witnesses, Mr. Laws?
I have no further witnesses. I have no further witnesses.
Okay. All right, thank you. Tommy, at this time, you can present evidence. If you'd like to be sworn, come forward to be sworn. And we also need the interpreter to be sworn as well.
Raise your right hands. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Okay, Tommy, you can call your first witness.
I don't currently have any witnesses at this time, sir.
Okay, is he prepared to present testimony on behalf of the church himself?
Yes.
Okay, go ahead with that, and if you need to interpret, please do so.
Sure, and may I go ahead and start, sir?
Yes.
I So when we first purchased the property for the use of the church, I was not made aware that there were any issues with the property or the building there. So the issues that they had documented here in the reports were all issues that were there prior to us taking the property and residing there. And during that time, there was not one person that had warned us or told us that it was not safe for safe for living or occupancy. And as I've mentioned before, I'm not from this country. We come from a different country, and over there, they do not have any form of building codes or any sort of codes.
Objection. The relevance of building codes elsewhere matter none to the proceedings today.
Was that overruled, sir? May I continue? Okay. And so in our country, our home country, they don't have building codes. And so we were not familiar with any of these codes and the things we had to do to maintain the property. We were just so excited to have a place to live, a place where we could also be together for church services. Yeah, and then initially, when they had told me there were issues with the property, I was completely shocked. I was taken off guard. I didn't realize that there were issues that needed to be addressed, and I wasn't sure how to address those issues moving forward. And also, I have here in the pictures that I brought myself for my own report, that when they had addressed issues, I know there was some issues with locks and doors, and some of the other problems. There was a section that was particularly badly damaged, and we went ahead and we fixed those right away. We wanted to make it safe, especially for the children. And then, according to my knowledge, there was sort of a pause in the process of all of this. I understood that the city wanted to help us, and so my understanding was there was kind of a pause on those inspections, and they wanted to assist us. And so I was waiting for assistance, and then it was during that time that they told us they were going to kick us out of the property. My purpose for coming today, I was hoping to show you with the evidence I have here in these photos that we did take care of some of the issues there. We fixed a lot of things, and I wanted to ask if we could get a full permit or possibly some extension time to resolve some of the other matters. For example, in the cafeteria, you'll see in this picture, all of the windows were broken, and we were able to replace those and fix them in this picture here. And we are trying to do the best with what we have here. We are trying to follow the codes and what they say. We know that this is how we're supposed to be doing things properly. However, there are some things that we differ on as far as what the city deems unsafe or not. Yeah, so I also wanted to just, again, sort of bring up the point that I would like to see if we could have sort of a grace period, an extension to take care of some of these issues here. It is true that I believe it was in 2022 that there had been some issues raised. But as you know, it is a place of worship, it is a church, therefore it's, nonprofit. We're trying to do the best that we can as a minority group living here in this state. We have several people living on the property that are working right now, about 14 workers, and they're doing the best they can so we can raise funds. I know one of the electrical issues that we had to take care of was between $1 to $2 grand. Yeah, and the other thing I wanted to bring up too is that there are several people living on the property who, they were kicked out of their prior living situations. And so as a church, we came together and tried to help them, provide them a place where there's a roof over their heads to help them. And they aren't paying rent, but some of them have been able to go from being homeless to getting jobs. Yeah, and like I said, they're not renting.
Recolok jondolin cimangan carom. Enangul lima buingan rin.
Sorry, repetition for the interpreter. Yeah, so I wanted to kind of break down some of those costs. Like I said, the people that are living there, they've had to pay upwards of like $1,000 for electrical bills.
Objection, he can't speak to what others have had to pay.
I guess what I was trying to say was that it affects every person that's a part of the community there. And I was trying to show how that affected them.
Is that the only copy of the photographs that he has?
Yes, sir, that is correct. Like I said before, I had no prior knowledge before today that I was, supposed to be here and bring multiple copies for everyone. I just thought if I made a report on my own and I submitted it to the board, that would suffice. Yesterday, I spoke to the city, and they said I did not need a lawyer or anything. I just need to bring a
Objection, he can't
report.
speak to what the city told him, it's hearsay.
Sustained.
Who's he talking about? Is the city? Is the city involved?
No, he's referring to this county as the city, in my opinion.
Then it is confident. The staff, the county staff.
When you say city, do you mean county or city?
Mr. Holdman?
It's confident. Objections overruled.
So can you repeat that statement about who he talked to?
Yes, sir. So I spoke yesterday to Mr. Holdman, I believe? Holton, I'm sorry. Mr. Holton and his boss, they had told me I did not need legal representation at the time.
Okay. Can he present those photographs as an exhibit?
Yes, sir.
Okay, we'll accept that package of photographs as exhibit number 6, I believe. Any further testimony? If you'll present those photographs to the clerk, please. Was there any other testimony?
Yes, the last thing I would like to say is just, I see these pictures here, I see the reports and inspections. I know there are some things we need to take care of, and I know we can do them as a community. I know we can get together and take care of what needs to be taken care of. And all I am asking you to do is to just please give us some extra time, an extension, please. As you know, there are babies and children, kids in school living here, and I don't know where anybody will go if we get kicked out. At least we're living somewhere we have a roof over our heads, and it's better than living out in the bushes with no support.
All right, that's the end of your testimony.
Yes, hold on. Yeah, so, if there's anything else, I can let you know later. At this time, I don't think I have anything to add, except there are some extra pictures here, different buildings and I think different property here. But there are certain people that I know are not following code. They're living in
Okay,
conditions
Objection
that,
to, first, the pictures that are not in the record and to what other people are doing.
Sustained. Do you have any other relevant testimony?
You can accept anything he wants to present.
I'm good for now, thank you.
Okay. Mr. Laws, would you like to cross-examine?
Yes, just. You stated that nobody told you before the purchase that there were issues with occupancy. Is that correct?
That is correct. In the beginning, I did receive some paperwork that said like there's no lead poisoning and no other issues. All the other issues that have come after the fact are new to me.
But you did have a hearing on these over 2 years ago, isn't that correct?
To my knowledge, I'm not sure if hearing is the accurate word, but I remember that I came here, I filled out some forms and paperwork and submitted them, and that's all I remember. And I brought permits as well, and so I was thinking that was what the hearing encompassed, so I did bring some forms.
Nothing further.
So, Mr. Chair, I think it's appropriate this time to let the petitioner know that this is his time to present all the evidence that he has, and his comment that he didn't have anything else to say at this time, this is the time to do that. And that if he has any witnesses here who can testify or wish to speak.
All right. Tommy, this is now the time, if you wish to say anything further, if you have any other witnesses or wish to present anything else, we need to hear that now.
Thank you, sir. I don't have any witnesses at this time, but I will submit these photographs for the record.
Objection, I have not seen those yet.
Okay, let opposing counsel take a look at those.
I would object to those. Those are random pictures of other properties throughout the community. They are nothing of this current property.
What's the relevance of those pictures?
It's some evidence of anything taken. There's evidence of nothing taken. Doesn't have to be compelling.
Yes, sir. So the purpose of these photographs that I wanted to give to you today are, I was just trying to show you that there are some other houses and properties within the community near us that are not following the codes or the law, and so I was
Objection,
just
he can't
asking
speak
why.
to whether they're following the code or not.
Sustained, those cannot be accepted. Okay, Tommy is finished with his testimony. And
Nothing further at this time, sir.
okay, I'll give our judge panel time to ask any questions they may have. I'll start with Mr. Barry. Any questions?
And Mr. Chair, sorry, I would, before closing, like to recall Mr. Holden to the stand when possible for just a quick moment, whenever that's possible.
Okay, let's hold on that just a moment, please.
Ask the audience to this one.
Mr. Barry?
Pastor, this has been going on since before some of us were here as commissioners, and we've been given the evidence of the violations at the building, which is
is pretty heartbreaking and concerning. My question to you is, with these documents and an interpreter being shown as evidence, being present at the time of the 2022 inspections, did you fully understand the documents, the interpreter explained that to you? And I'm just curious, if you have some interpreters, did somebody not say perhaps that you should have some legal counsel?
Yes, sir. So there weren't interpreters that fully explained everything in these documents. I did not have any legal counsel as well. I was just following what I was being told, and so that's what I did.
I don't have any other questions, and I'm not sure exactly how we take the vote, if it's all at once or not, but I do have comments. I'd prefer to vote individually when it's my turn to vote. I understand it's not time, but what I'm saying is, when we vote, I'd prefer to vote individually and make comments when I vote.
Mr. Smith, any questions?
Yes, sir. Is there a mortgage on the property, Pastor?
Can you repeat for the interpreter, please, at what now?
Is there a mortgage presently on the property?
Yes, sir. We are presently paying $500 a month towards the mortgage.
When you bought that property, were you represented by a real estate agent here in Burke County or somewhere in North Carolina?
No, sir, there was not a real estate agent. I spoke to some people that were part of a Baptist church, but I went myself and took care of things on my own.
Was Pastor Rice the minister there at Living Water when you purchased that property? Do you remember?
Are you referring to Chuck?
No, probably not. When I was the principal at George Hildebran, he and I had a close relationship, and he would come over and minister to the children quite a bit. I didn't know if he was still there or not, but
No, sir, I do not know who that person is. I haven't met them yet.
now, I'm sure you had a lawyer, legal counsel, when you purchased that property. Is that correct?
No, sir. Like I stated before, all of this is fairly new to us. So all I knew was to go purchase the property and that we would be making monthly payments towards the mortgage, but I had no knowledge of any sort of legal representation, attorneys, or anything like that.
I may have more later, sir, if you want to go through.
Mr. Stroud, any questions?
Hey, Pastor, I've done 40 years of ministry, so I know how it works on both sides, and I know that you got to do things that are right to honor God, and, you know, if you believe those kind of things. But here, I believe, me personally, you know, you've had plenty of time to figure all this out. You got a large support of people here in the community, it seems like, that are really rooting for it, and all of us are. I know all of these people here are God-fearing people, so we want the best for you and our county and everything else, but everything's got to be done right and got to be proper. And I know we all struggle to do those things sometimes, but I can't see going on any further just because of the liability. Now, we might come up with something, I don't know, but it just don't seem proper to me, and I like doing things proper. I've done things wrong too. I know how it is in other ministries and churches and stuff like that. You know, you come in and you're just trying to do good, and we appreciate that. And there's a lot of people trying to do that, but we want to do good right. We don't want to be liable. We don't want to be liable if a kid gets hurt. You know, everything's about helping people till somebody gets hurt, and then we're the bad guys. We're the ones that get sued and those kind of things. So I'd like to set a standard doing things the proper way, moving forward, and I think there'll be a lot of support for you in our community, and things is going to be good for all of us. But that being said, it's just kind of a no for me.
Excuse me, sir, did you have a question for me? Yes,
Question? Yes, I'll
Yes,
take a
sir.
question. Why so long? After time, after time, after time, after time, it would seem like somebody come on Living Waters, I don't know who they are, but it seemed like a minister or somebody would say, hey, man, we got to get this place right. We got to do this right. So why did it take so long to get it right from your perspective? Broken toilets and stuff.
Yes, sir. So from my perspective, the reason it took so long was because we needed to be able to raise funds to pay for some of those issues to be fixed. There were quite a lot of expenses, and from a few years ago, from 2022 until now, we've been able to fix some of those issues on our own. We were told that there would also be some help coming from some different organizations, and so we were trying to get assistance and also waiting to be able to pay for some of these things, you know, because things are kind of tight these days, and so that was the main reason.
Thank you.
All right, Mr. Laws, I believe you wanted to bring Mr. Holden back to the stand.
You're still under oath.
Mr. Holden, the pastor said that you told him that he did. The pastor has mentioned that you spoke to him and told him he did not need legal representation. Is that true?
No, sir.
Have you ever told him he did not need legal counsel?
No, sir. I advise him that everyone has a right to seek legal counsel.
Nothing further.
Any questions for this witness?
Yes, so when I spoke earlier, I was speaking of Mr. Holton as well as his associate, and I know there were other people higher ups that he worked with that they didn't, I don't know that they expressly had said that I was not allowed to seek legal advice, but I was not aware that that was an option. So I'm speaking of him and the other gentleman that came along with him as well to those inspections.
Mr. Holden, at this point, now that we've had this appeal, what is the time frame going forward?
60 days. It would be May the 20th.
There's 60 days from this
From the
date,
date of the hearing, of the order,
from the date of the order?
the date of the order that I'll give on the last hearing would be May the 20th.
When was the last inspection at this location?
Let me get my phone. April the 23rd, 2024.
April 23rd, 2024. Tommy, how many days do you think it would take to make repairs sufficient to?
Thank you, sir. I think that at this time, if I can get all the forms I need necessary, the permits, as well as everything moving forward and trying to work on everything as best as I can, I think it might take somewhere around 12 months, sir.
Mr. Holden, so you haven't been on site since 24, is that correct?
I was on the site last night at, say, 6 o'clock.
But as far as an inspection that would have seen any improvements, when was the last time that
It would
you?
have been, I have to look that date up, Commissioner. We posted it as unsafe and was on the site on March 11th, 2025.
So was there an inspection at that time?
At that time, I done a walkthrough.
You did not see any improvements at that time?
No, sir. But I only went into, I didn't go into every room, but I only went into maybe 4 or 5 rooms and then over into the church.
Would staff consider an extension of 30 days to re-inspect for any improvements?
No, sir.
Okay, Mr. Smith has a question.
I've got a question sort of for both of the pastor and Mr. Holden. Now, Pastor, I see where it says you had an architect in there in November of 22, and a contractor, a local retired contractor, also met with building officials. Did they give you any kind of an estimate on price? And I know that's going to be different now. An estimate on price and timeline, how long it would take them to repair that? And I'm going to want your opinion on that too in a minute, Mr. Holden.
Yes, so there was an architect that came to the property. I know there was some paperwork. I do not recall at this time if there was an estimation as far as how much money it would cost, and I don't recall that. But maybe it was there in the paperwork and I just didn't know where to look for it. So like I said, when the architect came, I know they did fill out some information. I'm not sure if they gave that to the city. My understanding was they were looking to see if there were walls and proper rooms in the structures there. And maybe they submitted those financial results. I'm not aware of that this time.
So,
You go ahead.
so on April the 3rd, 2024, with an interpreter, we went through the whole project, and then that quote, I believe, was $500,000.
500,000.
And I'm so sorry, Mr. Holtman, what was the date of that, that you just said?
It was April the 23rd, 2024.
Oh, yes, you are correct, sir. I remember that, and there was an interpreter present at that time, another Marshallese interpreter, and my understanding at that time, I thought that there were going to be people writing grants. That's what someone had mentioned. There'd be someone writing a grant to assist with the financial aspect of those repairs. I was under the impression that they were coming on that day in April to help see where we needed assistance and what needed to be fixed. I didn't realize it was like an actual like inspection that was going to be used to be submitted to the city. I thought it was supposed to be time that they're going to help us see what we needed help with and what we needed to be fixed. That was my understanding.
It was both. It was an inspection, and it was bringing in a group of people to look and see if there was help.
Pastor, if you were to get a continuation based on the $500,000 estimate, which I don't know after everything that's going on the last few months, if that would even be feasible now to say it would be $500,000, is your church, and I don't know your finances, through tithing and grants and all that, would you be able to feasibly afford a $500,000 renovation within a reasonable time period based on what the inspectors and contractors think it would take to repair those buildings?
Macam kacung kemalan maru bagian tabak. Macam kacung kemalan bagian jen maru tabak. Oleh benar kacung kemalan pramu malai. Mencong dalam maru kemalan baran tabak. Kena ke cuaca ni ya kena ke. Ngai rajab tabaraga yura rian ke rajab pero cara yura rian rajkan ni abu gejer dengan kalau magamiatan magai or kau sahaja sih kan magami yang juga mana yo yang dia lalu tu pun warkan minum baru baru mencipta yang yomen yein baik ni cepat pergi yein air kanya aku gejer katuk cerwal ngalai Marong marangan mo. Aji kacung kemana pun tawaran makan kemunculan but estimating.
Yes, thank you for the question. So that was kind of why I estimated maybe it would take 12 months due to the amount that is needed. We'll try our best, and I know like we work together as a community to do what we can. But I was thinking if we had that length of time, it would also help us to make sure that everyone living on the property has a place to go in case we have to vacate the premises. I want to make sure they have time to be able to fill out the paperwork to get housing or other things, and make sure that they are secure financially before having to be put out on the street. So I was thinking, you know, we'll do our best, we'll try. And that's why I mentioned 12 months earlier, sir.
In order to secure a line of credit or something of that nature? I know that would take probably in the neighborhood of 60 to 90 days just to get the line of credit if you had to do that. And my next question before I make a statement is, where would your tenants go while you were repairing the property? I don't imagine they could stay in there while you were doing that kind of work.
Chú đến gọi em mình cái chữ gì thì cái chữ mình cái này mà cái ngày là cái tao nào gì vậy mẹ rồi chú cô sao gì em nghe rồi tôi rồi thì ở đây là em chơi mà cái này em chơi cũng như tôi không cần nuôi tôm rồi này vật cái chữ mình là em cũng bảo cái nào cũng cái gì rồi Barang muara jen, cunya, ini kacung cibang cuma ada
Yes, sir, that's a great question. I know some of the people living on the property are filling out applications for townhouses, rental assistance, places for them that they can stay. I'm not sure when those will be processed and when we will find out if they have a place to stay, but I know that some of the parishioners are looking for stable housing at this time, and hopefully it'll be soon.
Other questions? Any other questions for Mr. Holden?
I'm good. Just thank you for your time. Thank you, sir.
Any other questions, Mr. Laws? Okay, thank you, Mr. Holden. All right, Mr. Laws, would you like to make a final statement?
Today's hearing, through all of the evidence presented, should show just how dangerous the conditions currently are at the Marshallese New Beginnings Church. The experts have testified to countless code violations, including exposed and overloaded wiring, no real source of heat, walls that are falling apart, completely unsanitary bathrooms, lead paint, and leaking sewage gases, just to name a few. This all going on while the building is not even designed for residential occupancy. Drastic changes need to occur and have needed to occur for years in order to make something like that a viable option. And the county has been trying for years to remedy these issues. And at every juncture and every opportunity, they refuse to take measurable steps to comply. And he admitted to knowing that these issues have existed for years. You've seen the prior building permit and the record that followed. That permit was allowed to expire after not a single thing was done. And I'd like to go back to what I briefly spoke about in my opening statement. A quasi-judicial hearing is not a popularity contest. It is a decision constrained by the standards in the law and based on the facts presented, and your discretion is limited. Your decision can rest only upon the competent, relevant, and substantial evidence that has been entered into the record today. Today's decision is not a political decision, despite, however, the contrary it may currently feel. The decision has already been made, and it hasn't been made lightly. The church has been given the necessary steps it needs to take in order to remedy the dangerous conditions at this property. Nothing in that prior order is stopping that. It's just merely, as it stands, it cannot continue to be used in a residential occupancy capacity. Nothing has been done to stop them from conducting religious gatherings or even making the repairs for future occupancy. It's clear that notice and hearing were conducted as the law required. The church is incredibly dangerous to life, health, and property, and those are the findings Mr. Holden was required to make under state law, and those findings don't actually appear to be very disputed. They have clearly not met their burden of proof here today to show otherwise. If you allow continued residency there as it stands, someone is going to get seriously injured or killed. For those reasons and everything else in the record today, we would ask that you affirm the decision as stated previously in Mr. Holden's order. Thank you.
Thank you, Mr. Laws. Tommy, do you have closing comments to make?
Okay.
Vậy chỉ lúc con có mơ là cần concern đó, cần save. Ngay chỉ lúc con đi lại là reality cái all of it would teach them like chim nó lên cần tao đi qua mình chua nào ngay em mất mi vào một cột trên bay vô Ecclesiastes kali तक चलता है एक kali कर गए चलो चुन मार में जमारों रेवी नूर रहना em चलो चुन मारों रेवी जान चेन em Ijilale nu jagane ke eleng imrol kun shape ilo nu jagane akore collapse. Ak kemar beriumun muen yumun chiluri jangan war chorren. Ano dawa.
Take a look at that before we make a decision.
Ijaji ijume be bangan ko ba. Jema ani jo de komal ne ro
Yes, so first of all, I just want to say to everyone gathered here today, thank you so much for coming here. Thank you for your time. Thank you for your safety concerns and for the concerns of our community. I think the reality of the situation from my perspective is that although there were permits and codes and paperwork discussed, I didn't have a full understanding of everything presented. I didn't understand how dangerous some of the things were that they had mentioned in their reports. And I don't know if it's proper for me to quote the Bible, but I was just reminded of a passage in Ecclesiastes chapter 8. And it basically says that God is in control. Humans can make their decisions, but in the end, God has the final say. And I've seen from personal experience and also in the news, I've seen there are places that are up to code and they collapse or they have issues and there are injuries to people. And I mean, we've been living there at that property for over 3 years now. We have not experienced any of these issues that were mentioned. There hasn't been any danger or loss of life. And that's why I'm kind of just reminded of that passage in Ecclesiastes that everything is in God's control. And I'd like to say a little more as well.
Amargar keciuman kembali cuan kawajarat tarinayo kemciong lagi kemiyit melorar kembali ngan pen en pejaro pen jalo en rigolo en iya tolo karam yurimi kembali itu kerar teje pamo kangan stop pen yang ngan arum jutu jis kem and kem ra sacrifice kem ra tan ra relo kem kan mini kan chorrain pen no rainin yelang nur rosi kemar rarte jo pamo jo ngal kawajarat tarina ngal rainin kemijan shape jangan kemal banget dia kemi still unsafe but ak meno money kaya ani chipang.
What I also wanted to mention, as I mentioned before, we are not from here. We are a small community of believers that come from the Marshall Islands. And I know a lot of people might not be aware of this, but when the United States was at war with Japan and Germany, and at the ending of the war, when they decided to drop the bombs on Nagasaki and Hiroshima, the ability to be able to test those bombs and to use them as an act of war is because of the Marshallese people and their sacrifice, and because of what took place. We were a small nation, we still are a small nation with few people, but we were told by many, and specifically Henry Kissinger, that this was for the good of mankind. And so many of our people were sacrificed, and we still have repercussions with many illnesses due to this day, due to the poisoning of several of the islands out there during those bomb testings that took place in the 40s and 50s. We've always been a people at peril. We've always been in danger. We have always had issues due to the things that were done to us, and yet we do remain hopeful, which is why I had mentioned God before, that He's taking care of us. But every place that we have been, I feel like there have been issues and things and perils that we have faced, that we have faced, and we've still been able to overcome them.
Ngan safe ngai rai bat in safe with a definition na pe injara in safe or one man em chalo mileni barong wai kana ron tomolo la ni tomolo la ko ri chuta ipem ilo kata bargen ngan extension tomolo.
And the last thing I just wanted to say to wrap things up is that as a nation, the Marshallese people have faced peril and danger due to the poison that was dropped on our islands many years ago, due to testing, due to basically being guinea pigs by the government. We were deemed unsafe. We have always kind of lived with this mentality of we're not really safe no matter where we are, and I understand that there are laws and codes and things for our safety and our own good, but I think because of the things that have happened to us in the past, we understand that nowhere is truly safe, and so I think that's pretty much everything I just wanted to say today. I appreciate everyone's concern, and I appreciate everyone coming here to support us. I know there's people behind us, standing behind us. Again, I would just plead that you would be able to give us a grace period to be able to fix these things, these concerns that the city has. And that's everything. Thank you.
All right. Thank you. With that, we'll close the testimony at this time. And gentlemen, in just a moment, I'm going to entertain a motion to either affirm with modification, or to revoke the order to vacate. And as we've been reminded, we are to consider the facts and evidence in the case. And just before I call for that motion, I will give you, the commissioners, one last opportunity to make a comment. This won't be a period of questions, but any comment that you wish to make before I call for the vote. Barry.
Thank you. Pastor, this is an unusual situation in that we are sitting up here in this capacity. It has been a little confusing to myself, to be quite honest. However, when I agreed and got elected as a commissioner, we all had to take an oath that we solemnly swore that we would maintain the Constitution and laws of the United States and the Constitution and laws of North Carolina. And what's been presented here on the county's behalf, in my opinion, is direct evidence of violations of those laws. I personally don't care for that many laws, but I have to follow them too. And it is heartbreaking. My concern, I haven't slept since we've talked about this because I have this fear. In your country, you may not experience the kind of electricity we have, the sewers, the things that are very dangerous here. Perhaps you haven't experienced that here, but our EMS and firefighters and folks go out to these kinds of calls due to faulty wiring and these code violations. That's why we have the laws, because children have died, adults, animals have died, and it's very difficult to know that that can happen and that we would also be responsible. And our obligation is to follow the law. So it's not personal to me. It's certainly not political. However, on one hand, we have the law that we are sworn to follow. And on the other hand, we have care and compassion for people in our community. So it's a very difficult situation. My understanding is if this ruling is affirmed by this body, you would have a right to appeal that decision before, that would go to a superior court judge, I believe. I'm no expert, but I think that's correct. I have some concern that there were no legal representation here on your behalf. I feel like as much of interpretation and the folks that have been with you for 2 years now, I kind of feel like that would be known, but I can't say that for sure. That's all I have to say. Thank you.
Mr. Smith?
Yeah, I'd like to say, first of all, that I'm responsible not just for the folks down there in George Hildebran, but for about 90,000 other citizens. And I guess I've got another question. Let's just say that we did modify this or give a continuance or something. Would my other 90,000 citizens be responsible if something terrible happened down there or not? Who's qualified to answer that? We have two attorneys in here.
Let me ask, so you're saying if we modify it, how are we gonna be liable in the meantime?
Yeah.
We still gonna be liable, right?
Would we, ma'am?
I don't have enough information about the background of this.
Okay. But I got to tell you, Pastor, that's my community. That's where I went to school. That's where I grew up. I love George Hildebran. Outside of my wife and children, my fondest memories are that place. And just looking at the pictures that you took of the cafeteria and the auditorium, I'm very impressed with what you've done. You are very, I don't know the word I'm trying to find now. I'm all choked up a little bit, but I'm impressed with what you've done with the cafeteria. If you could do that with the rest of it, because I would hate to see that building vacated and torn down and all that. And I'm tickled to death that we got folks in there, good people in there that want to continue that building and making it look good, and it's good for the community. And your children don't have to go far across the road. I was the principal at George Hildebran also, and I went to school there for 9 years. I've got a lot of my life invested in that place. And I think y'all are a good group of people, and I'd like to see you stay down there. And anything I could do to help you, I would be more than willing to do. And I guess I'll close with that, but that's not to say that I don't have any faith in our county inspectors. I do. In fact, this young man over here, the head inspector, I taught him a few years ago at George Hill at East Burke High School. So I know he's a good man. He's not out to get anybody. I know him personally for a long, long time, and I think you're a good man too. That's all I have for right now, sir.
Thank you, Mr. Smith. Mr. Strauss.
Yeah. Thank you, Pastor, once again, and all you guys. You know, we love you, and it's a consensus here. You know, we're concerned about all our citizens completely. Appreciate you mentioning the scripture. You know, we all believe those kind of things also. I always think about the scripture, my people are destroyed for lack of knowledge. That's one of the things we got to first apply. I've been dumb in a lot of things on laws and things like that, and ignorance of the law is no exception, right? That being said, I'm like Brian and Phil. I think the community will gather around you, but outside of the things that's already been done, it's hard for me to say yes. I just think there's got to be a point where we're not liable. This is all good right now. I just think, when somebody gets killed, boom, yow, okay, what did y'all do? And I know that you haven't had any problems. There's a lot of churches like that. A lot of churches are trying to build and expand and deal with monies and finances and all those kind of things. I understand that completely. And this seems like an astronomical amount. But that being said, with the law, it's hard for me, when this much time has gone by, that we can't get some kind of counsel from Living Waters or whoever. I mean, I don't know. I think the churches have to rise up and give some counsel like this. And, we're going to help things out. But, for me, it's a no still, in this regard.
All right, thank you, Mr. Stroud. With those comments, ladies and gentlemen, we've heard the evidence from both sides. I will entertain a motion at this time to either affirm with modification, or to revoke the order to vacate these premises.
Mr. Chairman, I would like to make a motion to affirm and modify the order to vacate issued by the Burke County Chief Building Inspector for the annex structure of the Marshallese New Beginnings Church located at 8123 George Hildebran School Road, Connolly Springs, as follows. The modification would be a 30 days continuance with written estimates from a reliable state-approved contractor, a line of credit from a banking institution or some facility of that nature, written, that we could look at in 30 days, both of them, and/or grants that you get, if you could come in with some kind of proof that you've applied for grants and stand maybe a good chance of getting those, I would make a motion that we do that.
Council, is that motion all doable? Not doable, but
So I think what you're asking, what you're making a motion on is to a 30-day continuance of this body's making a final determination based on the criteria that you just put out there for
Yes, ma'am.
the church to come up with those three criteria within the next 30 days. And at that point in time, have this body make a decision?
That's correct.
Your decision needs to be made within a reasonable time of this hearing, and what you're doing is asking for additional evidence in order to make that determination. So I think that's what you're asking to do, and yes, you can do that.
Okay.
so we are affirming the order to vacate with the modification that within 30 days, we'll schedule another hearing.
I don't know that he's asking for a hearing just for additional evidence to be considered, whether you want that in written form. You said written format, so it would be a written submission for your further consideration.
Yes, written from a state-approved contractor, a financial institution like Bank of America, First Citizens, Wells Fargo, something of that nature, and/or some type of private or government grants like Dogwood or something from the U.S. government or whatever.
So to clarify, you're asking that this order be affirmed, but that it not be acted upon, and basically giving another 30-day stay to see if the timeline may change.
Right, and I'm trying to give 30 days, I think, should be ample enough time to at least get a contractor and the financial institutions to tell us whether or not that's feasible. And
Mr. Chairman, what we gonna do in the meantime? That's what I wanna know is how are we liable, in that 30 days? I mean, is this the same thing apply? They still operate with everything like it is now for 30 days and something happened in that 30 days? And then we come back here and he's presented all this stuff, or what's the in-between there, this 30 days, if this is accepted like this?
I think if it's accepted as 30 days, everything's going to stay just like it is for 30 days. At the end of that 30 days, the way I understand it, counsel, and you help me if I'm wrong, but at the end of the 30 days, the hearing's already over. We've already affirmed the vacation. If we don't see some evidence that they could obtain loan funds or they could obtain some means to repair and continue to occupy the building, then gig's over. We don't have another hearing. So how do we go about coming together and reviewing that information, counsel?
A couple of things you could do. One is modify this to give them an additional 30 days, 45 days, whatever, to come up with but with 30 days to come up with a plan to implement something and send that back to the building inspector for further consideration. That would be a modification. You could also continue this entire hearing for a 30-day or whatever period of time for continued consideration of how they can accomplish the modifications, the renovations that need to be made. And that would, something certainly would have to be reviewed by the fire marshal and the building inspector, as to the viability of it. In the meantime, you still have people living in a facility that the majority here has indicated they're concerned about, that the building inspector and fire marshal's order needs to be upheld if it's not corrected. So corrective action, how long does that take? You do have the ability to extend the time for corrective action if you're seeing and you're saying if we're seeing movement, we would extend that time. So I would say reconvene after the written information is provided, which needs to be provided within 30 days. If it's not provided, then the order goes into effect. But you could reconvene to consider modification based on that information.
I'm just trying to get us, where do we end?
Yeah.
So 30 days, so you're suggesting that we make that as to continue the hearing for 30 days, then we come back together and look at that evidence, this body, and decide we're not hearing any more testimony. We're just going to look at that evidence. If it's not there.
That's what I'm suggesting, yes, sir.
If it's not there, if they can't make those provisions, then the answer is easy. If they come up with something that we want to consider and give them any more time, then I suppose we could do that at that time.
I guess my thing is still is the liability with the kids. Okay, they get all the stuff together, that's great, I want it. I want it, trust me, I want to build the whole county. Yeah, everybody knows that. But in the meantime, we're liable in that 30, are we not, counselor?
If it's 30 days, that's still prior to May 20th, right? So 30 days is inside the window. They have until May 20th to vacate today. 30 days gets you to May 10th. So we're still inside that window to present additional evidence. It doesn't extend that.
Okay, I think we all understand the motion then, 30-day continuance of this hearing. We'll need to schedule then we'll have to figure out when we can schedule that hearing, but it will be at least 30 days. And then we will determine when we can have that hearing, and
Because you're asking for, to consider, you're asking for the presentation of additional evidence to consider that must be presented to this body. And you'll be given, and they will be given direction as to how to do that, obviously. And then you will reschedule a hearing for the consideration of that additional evidence as a group, but not to consider more testimony.
that's right. So will those directions be drafted by you? Okay. Does everybody understand the motion?
Have you modified your motion?
I did when I presented it.
No, have you modified the motion that you presented, that you're asking for a 30-day continuance of the hearing to consider additional evidence of A, B, and C?
I thought I did, but I'll go do it again if you want me to. Mr. Chairman, I'll make the motion to affirm and modify the order to vacate issued by the Burke County Chief Building Inspector for the annex structure of the Marshallese New Beginnings Church located at 8123 George Hildebran School Road, Conley Springs, as follows. 30 days continuance, which would take us to May the 10th, I believe the manager said, with a written estimate from an approved North Carolina contractor, a written line of credit proof from a financial institution such as Wells Fargo, First Citizens, Bank of America, and or proof of grants that they can obtain from either the government or a private entity.
One more clarification, and I'll address this to the inspector. The testimony that we heard, I believe, included evidence from both of the buildings that are on the property. And your order, I think, is to vacate 8123 George Hildebran School Road. So I need to understand, are we talking about all the buildings on the property, or are we talking about just a particular building on the property?
We're saying that with the educational occupancy and assembly, they can have church, just can't reside there. Both buildings.
So in terms of vacating the premises, we're talking about
It's
vacating
the living.
the
Just
annex,
cannot live there.
what we would, it doesn't matter. So
That's right.
in other words,
Both structures.
so our motion probably should not call out the
Yeah.
annex, because what we're saying is we've looked at both buildings, and neither of them are satisfactory to live in.
That's correct.
So our motion should not include the word annex, because we're talking about cannot live on either structure on this premises.
That's correct.
So
It's my understanding that they use the basement area of the main building, which when I went to school, there was the old special ed, what they called it then, classrooms. And, so if we need to include, if we need to say annex and the basement part of the main building where the sanctuary is, do I need to modify that and say it that way, or what?
I think we just need to remove the word annex. I mean, the point of this is that you cannot live, neither of those buildings are lit, to be a residential building. So they can continue to have church
Yes.
For the purposes of assembly.
for the purposes of assembly, just,
But I think we need to amend the, whatever the attorney is going to write up, I think we need to say that it's going to include the living portion of the main building when they get a contractor and a line of credit and the grants, not just the annex, but the living portion. Any part that they want to live in that building is going to have to be
Living
one of the
quarters.
three things I gave you there. The contractor's gonna have to inspect it and all that and see what, and give an estimate on it.
So one further clarification, this written evidence is to be provided by the church.
Yes. Yes. The church will go out and they'll have to get the contractor, the banks and all that, because I don't think anybody up here wants to take that duty on. So that pastor, that's going to fall on you, sir. Okay? We won't be doing that. I want to make certain you understand that. It'll be the church and you getting, ramrodding the contractor, the banks and the grants and all that.
Okay, do we, everybody understand the motion? Madam Clerk, do you understand the motion?
I do, but I have a procedural question. Are we, after some action, are we adjourning today or are we continuing 30 days out? And if so, that's May 10th and that's a Saturday. So are we going to just adjourn this and reschedule a new meeting within 30 days?
Can we continue to sometime after 30 days? And then, in the meantime, we'll determine a date that we can meet. Is that acceptable?
So he would need to have this information within 30 days, but that becomes May 12th because falls on a weekend. So the church would need to have this information delivered to the clerk within 30 days, on or before May 12th.
And between now and then, we would decide on a hearing date after May 12th. That work? You good, counsel? All right. Gentlemen, you've heard the motion. All those in favor of the motion signify by the uplifted hand. Madam Clerk, that's 4-0. I'd like to thank everyone for your presence today, for your testimony. I think it's clear that this board has a heart to try to help these folks do what they can. And we certainly want to say to our inspection folks that we appreciate all your efforts. Our primary concern, I believe I can speak for the board here, is the safety and well-being of the folks that are in those buildings. And so we certainly wish you the best in some way that you can make this happen. And we'll reconvene as the motion.
Has the board conferred upon you the authority to sign off on that order?
I don't want that to happen when we reconvene.
This order. The order that was just.
Okay. Gentlemen, council advises that you need to give me the authority to sign the order that we've just affirmed together.
Mr. Chairman, I make a motion that this board give you the authority to sign the order that we have just voted on.
All those in favor signify by the uplifted hand. It's 4-0. All right, again, thank you very much. We appreciate everyone's presence, all those who participated. And at this time, I'll call for a motion to adjourn the meeting.
Mr. Chairman, I make a motion to adjourn.
Thank you, Commissioner Berry. All those in favor signify by the uplifted hand. 4-0. I blew that estimate deal.